Section 23 of the Canadian Charter of Rights and Freedoms is the section of the Constitution of Canada that guarantees minority language educational rights to French-speaking communities outside Quebec, and, to a lesser extent, English-speaking minorities in Quebec. The section may be particularly notable in that some scholars believe that Section 23 was the only part of the Charter with which Pierre Trudeau was truly concerned. Trudeau was the Prime Minister who fought for the inclusion of the Charter of Rights in the Constitution of Canada in 1982. Section 23, or Section 23 as a whole, are also known as the Canada Clause. Under the heading, Minority Language Educational Rights, the section reads, 23. Citizens of Canada have the right to have their children receive primary and secondary school instruction in that language in that province. Citizens of Canada of whom any child has received or is receiving primary or secondary school instruction in English or French in Canada have the right to have all their children receive primary and secondary school instruction in the same language, to have their children receive primary and secondary school instruction in the language of the English or French linguistic minority population of a province. Section 23 must be read in conjunction with Section 59 of the Constitution Act 1982:59. Shall come into force in respect of Quebec on a day to be fixed by proclamation issued by the Queen or the Governor-General under the Great Seal of Canada. A proclamation under subsection shall be issued only where authorized by the Legislative Assembly or Government of Quebec. Comes into force in respect of Quebec, and this Act amended and renumbered consequentially upon the repeal of this section by proclamation issued by the Queen or the Governor-General under the Great Seal of Canada. As a strong federalist, Trudeau had fought to ensure linguistic rights in the Constitution to promote national unity. Section 23 had its origins in a unanimous agreement between the provincial leaders and Trudeau, reached in 1978 in St. Andrews, New Brunswick, in which children of citizens could receive schooling in their language. When this idea was brought to the Charter in the 1980s, Trudeau also successfully secured agreement from provincial leaders that Section 23 could not be nullified by the Section 33 notwithstanding clause. When the government of Quebec had passed the Charter of the French language in 1977, only parents who had gone to English schools in Quebec could have their children educated in English. Concerns for the erosion of the educational rights of English-speaking Quebecers thus led to Section 23. The Word Act prompted the passing of Bill 86 in 1993, which amended the Charter of the French language, stating that any child of a Canadian citizen whose parent or sibling had received English medium education in Canada could attend English medium schools. While there was decreased minority language education in Quebec at the time when the Charter was adopted, several other provinces had no French language schools at all. In contrast, in 2005 all provinces had minority language education schools. In 1986, 152,225 French-Canadian students outside of Quebec were going to French language schools in accordance with Section 23, and in 2001 the number was 149,042. There have been some roadblocks to minority language education since the Charter came into effect, such as a need for more French-speaking teachers and decreased enrollment in English language education in rural Quebec, as well as challenges from both francophone and anglophone minority parents that education of equal quality is not being provided by their provincial government. The relative lack of French language post-secondary education opportunities outside of Quebec influences the choice of some French Canadian students to switch to English language instruction, especially as they advance towards the end of their compulsory education. The rights of official language minority students remains a topic contested in provincial and federal courts, with funding for legal costs for court actions being provided by federal government's Court Challenges Program. Section 23 is a positive right. It has been found that Section 23 thus guards against linguistic minorities being assimilated if their educational rights are denied for a long period of time. And this has led to Section 24 of the Charter, which provides remedies for rights infringements to be applied flexibly and creatively. For example, in Duce-Boudreau v. Nova Scotia, it was found that the government could be forced to report to a judge as construction on schools progressed, in order to ensure the schools were built within a sufficient amount of time. While much of Section 23 can apply to Quebec, Section 59 of the Constitution Act, 1982 states that Section 23 is of no force or effect there. This was a conciliatory gesture made by the authors of the Charter, which F.A.